And good morning and welcome to an oral argument session in the 5th District Court of Appeal. We have on the docket here this morning at 9 o'clock, one case. It's Jake Adam Bellata versus the state of Florida. My name is Rand Wallace and I will be presiding over this oral argument. I have joining me on the panel Paige Kilbane and Judge Jordan Pratt. And just want to, for some preliminary matters, Mr. Crawford, I'm going to assume that you would like 5 minutes of rebuttal unless you tell me otherwise. And
that's correct, Your Honor.
That sounds great. And then just make sure I'm going to turn my noise-making device to mute and ask everybody else to as well. But for ease of operation, just mute your microphone when you're not speaking, and that will make sure nobody gets interrupted in their presentation. So that's everything for preliminary matters. And Mr. Crawford, you may proceed.
May it please the court, counsel, yes. Judge Wallace, Judge Kilbane, Judge Pratt. Good morning. My name is Andrew Crawford. I'm in here on behalf of the appellant in this case, Jake Adam Bellata. This case comes to this court after a conviction and sentence of life in prison for first-degree murder. There's multiple issues that I've raised in the initial brief. The issue that I would specifically like to talk to each and every one of you about today is the faulty jury instructions as it relates to self-defense. In this particular case, as we all know, self-defense is an affirmative defense. The defendant in this case, Mr. Bellata, did testify, provided affirmative evidence of that defense, obviously enough for the instruction to be given. In this particular case, the instruction that was given was incorrect in two specific places. The evidence is undisputable that Mr. Bellata was in a house where he had a right to be. If he was in a house where he had a right to be, his own house, he does not have a duty to retreat, and the instruction should be given pursuant to Florida Statute 776.013. In this particular case, that instruction in its entirety, without the duty to retreat, if he was not otherwise engaged in criminal activity, was not specifically given. In two places in this final instruction to the jury, with Mr. Bellata's only defense to the first-degree murder charge, self-defense, the jury was specifically instructed pursuant to the wrong statute, which is 776.012 and 776.013 sub 2. In those particular statutory schemes, the duty to retreat while engaged in criminal activity is specifically mentioned. The plain language of the statute in 776.013 specifically does not contain, sub 1, does not contain anything involved engaged in criminal activity and the duty to retreat. Now, in candor to this court, unfortunately, defense counsel did not object to this instruction. So this court has to look at this through the fundamental error standard of review. I would submit to the court, especially in this particular case, based on the facts, based on the affirmative defense and arguments of counsel, that fundamental error occurred in this particular case. I've cited a series of cases in both the 2nd District Court of Appeal as well as the 4th District Court of Appeal, where those districts found fundamental error in similar circumstances, which I would submit occurred in particular here. I would further submit that this error was compounded during closing argument when the state specifically referenced engaged in criminal activity, although they did argue.
Mr. Crawford, with regard to that question, engaged in criminal activity, there was some discussion in your brief about potentially other crimes. I guess there was a issue or facts that could have been presented and argued at the trial court about drug usage in the home. I don't recall the state even picking up that ball and arguing that position. I believe the state focused entirely upon who was the aggressor in this trial. Is that accurate?
That is accurate, Your Honor. However, the question is not what the state argued, but what the jury could have inferred based on the evidence in this particular case. Additionally, even though the state did argue the aggressor instruction, that instruction has zero language as it relates to engaged in criminal activity.
Well, what do you believe the jurors could have inferred after the facts were presented in this case? Quite frankly, I think the facts that were presented, except for your client, were pretty clear if the jury was to believe all of the other witnesses that your client was clearly the aggressor. Do you disagree with that?
I agree that the jury was instructed on the aggressor exception to self-defense. There's no question that that was read to the jury. The overwhelming evidence, though, was that the defendant argued self-defense. He testified in self-defense, and the jury could have inferred that based on the drug use, that could have been an exception because he was engaged in drug use during the day, that the jury could have believed that he didn't have to have the right to use self-defense because he was otherwise engaged in criminal activity. Now, Judge Wallace, I know that you were very active in these jury instructions that were submitted to the Florida Supreme Court, both in 2018 and 2019. And what the court ultimately promulgated was that circuit courts, when instructing the jury on these type of affirmative defenses, must be extremely careful when it relates to self-defense due to the multiple statutes, which is specifically noted in both the 2018 and the 2019 opinion that the Florida Supreme Court accepted. In this particular case, there is no question that the jury was instructed improperly, pursuant to the wrong statute based on the facts of the case. There was ample evidence that there was potentially other unlawful activity. There was references to marijuana use. There was references to cocaine. There was references to drug use. And viewed in that particular context, the jury, although the state necessarily did not argue that in closing argument, they did say that Mr. Bellotta was engaged in criminal activity. They said that during the aggressor, when they were talking about aggressor. However, if you look at that specific instruction, it has no mention of otherwise engaged in criminal activity.
Well, isn't the explanation, Mr. Crawford, the explanation behind that, given the facts of this case, you have the witnesses, Mr. McClurg, Mr. Johnson. There was words used that the victim was set up by Mr. McClurg. There was a plan that was at least hatched by your client communicating to Mr. McClurg. There was the event took place where Mr. McClurg apparently abandoned whatever agreement that he had reached and provided the testimony. Then you had the defendant going to the door with the weapon in his hand, and I believe it was in his predominant. He was right hand dominant. I found that interesting that he was carrying the knife in his right hand as well. And the state argued all of that was premeditation. And also, I think, didn't your client, after the event occurred and the victim was in the hallway, your client told Mr. McClurg, if he moved, stab him? I believe that was in the record. Was that record evidence?
I believe the majority of that was record evidence, Your Honor. However, that does not negate the fact that in a criminal defendant facing a charge, if he only has one affirmative defense, which in this particular case, his sole defense was self-defense, he has a fundamental right to be properly instructed on his defense, which he did not receive here, which was clearly contrary to the statute and the cases that I cited within the brief itself. I would also add, Judge Wallace, that he told the initial arresting deputy that he acted in self-defense. The victim in this particular case did not have any defensive wounds. In addition, the defendant's testimony and the crime scene photographs were consistent with what he did testify to. and there was a dispute, as there was a third roommate who did testify, who disputed the testimony of McClurg, as well as the other witness, the other roommate that testified, as it relates to a plan, as it relates to the defendant's action. So it's not solely the defendant's testimony that we have self-defense. There's other evidence in the record that causes some dispute, as well as the cross-examination of the state's key witnesses against him. But again, regardless of that, other courts have found fundamental error in similar circumstances, specifically in the Second District Court of Appeal and the Fourth District Court of Appeal, where the jury was erroneously instructed on the engage in criminal activity and the duty to retreat, which is what we have in this situation. Again, the plain language of the statute in this particular case was that there was no duty to retreat. And despite the fact the jury was instructed on that twice, the error was further compounded when the state mentioned engaged in criminal activity, although they said it was aggressor. The aggressor instruction has no specific language within the instruction that has anything to do with engaged in criminal activity. Therefore, by emphasizing that to the jury, it further highlights engaged in criminal activity and the duty to retreat, which the defendant in this particular case, Mr. Bellata, did not have a duty to retreat, despite the fact the jury was instructed upon that twice. The other errors that I have assigned in this particular case, there was evidence that came before the jury that was emphasized by the state in both of its closing arguments that Mr. Bellata had bragged about allegedly killing 3 other people, or this was his 3rd victim. Now, I understand that there was some direct examination about whether or not he considered himself to be a violent person, but I would submit to this court that it was actually the state that asked the questions that truly opened the door to this type of testimony. In a case where self-defense is the only defense, and it's an affirmative defense supported by the defendant's testimony, in this particular case, it was fundamental error that the state elicited during its rebuttal testimony that Mr. Bellata bragged about killing 3 other people. That completely weakened his self-defense, which again was his only defense. The defendant did not open the door to his testimony. Rather, it was the state that impeached Mr. Bellata during its rebuttal. And based on the case law that I've cited, it weakened his self-defense case and it rises to the level of fundamental error. In terms of the third issue, which is relevant to this court, for this court's consideration, is the unconstitutional restriction on Mr. Bellata and his counsel's cross-examination of, I would submit, the key witness against him, Ian McClurg. At one point, Mr. McClurg said that he could not specifically remember the answer to the question about how often Mr. Bellata smack talked, which was relevant to this particular case. Even when he was refreshed or attempted to be refreshed with his deposition testimony, he still did not remember. Like the Pugh case and like this court found in Elmer versus State, this allowed collateral evidence to be admitted demonstrating a prior inconsistent statement. Merely because he said he doesn't remember does not allow a witness to be impeached with that. It's very similar to the cases that I cited. Additionally, there was a further restriction on cross-examination when defense counsel was trying to impeach Mr. McClurg about his failure to include certain details in his deposition. The reason there being was there was an inmate orderly who was present during his deposition while at the jail, and that caused him to leave out certain details during the deposition, which he ultimately testified to at trial. A criminal defendant, especially when it's related to a key witness, as it was in this particular case, is entitled to very wide latitude during cross-examination, which was not given in this particular case.
And counsel, on the point with the collateral evidence and the number of times he had indicated previously saying that he would kill somebody, could that not be seen as collateral? Is that really material as to whether or not didn't he eventually say, I can't remember if it was once a week or, but it happened a lot. I mean, is that not a collateral issue? Why would we need extrinsic evidence on that?
Judge Kilbane, are you referring to the opening the door, or you're referring to the cross-examination?
The cross-examination.
Yes, ma'am. It's not, that would not be collateral because that is one of the things that he specifically testified to. It is, he said it inconsistently with what he testified to during direct examination. This was a key witness against the defendant. When it is a key witness against someone, it takes on, according to the law in Florida, it takes on a increased role of judging his credibility. I would submit that's not a collateral issue, but shows an inconsistency in his testimony, which is pivotably important, especially in a case such as this, where the jury actually during deliberations requested portions of his testimony to either be read back or played for them. In this particular case, it was not a collateral impeachment. It was impeachment on a direct issue, which was whether or not Mr. Bellotta smack talked a certain number of times, or how often that he did it. I would reserve the balance of my argument for the 5 minutes of rebuttal.
Okay, Ms. Davenport, you may proceed.
May it please the court. My name is Chris Davenport and I represent the state of Florida. I will start with the last issue and go backwards from how he framed the argument here. As far as the cross-exam of Mr. McClung, in order for extrinsic evidence of a prior statement to come in under the statute 90.614 subsection 2, you have to have two things. They have to not remember making it or not admit to making it. And the prior statement has to be inconsistent. The case law is clear that saying, I don't remember, is not inconsistent with a prior statement remembering. And they use the example of if the witness testifies in a deposition, the light was red, and then at trial he says, I don't remember what color the light was. You can't bring in that prior statement because I don't remember is not logically inconsistent with the light was red. Now, if he testifies at trial, the light was green, then you can bring in the statement that says, well, before you said the light was red. So that's how that works. In this case, we have Mr. McClung saying he said he threatened people a lot. He talked smack a lot. I don't remember exactly how often, but it was not uncommon. First of all, that's not inconsistent at all with once a week. I mean, I would submit they're about the same thing. But more importantly, saying I don't remember how often is not inconsistent with about once a week. So that's clear under the case law. I would also note that this is the definition of harmless, because how it would benefit the defense to have the witness say he was threatening people even more constantly than what the witness already said is beyond me. I think that was damaging testimony to them. I don't think that was favorable testimony to them. So clearly there's no error, or if it was error, it was harmless. As far as the collateral crimes, first of all, it's not collateral crimes evidence. We didn't bring in testimony showing that he had killed 3 other people. We brought in testimony saying he had told these guys he had killed other people. That's very different, especially when you consider the full context of this trial. This guy threatened people a lot. He talked tough a lot. He talked tough so much that when he threatened to kill the victim, nobody took him seriously until he actually arranged for the victim to come over. Because that's just the kind of guy he was. He just bragged about things like that. He was a tough guy who made a lot of those comments. And then when he testified on direct examination, not on cross-examination, on direct examination, that he never threatened the victim. He's not a violent person. The defense counsel said, have you ever in your life threatened to hurt someone in the past? And then I followed that up with physical violence. He said, yes, I had, and I beat somebody up in high school. That was the last time. Yep, that was the last time. That opens the door that needed to be corrected. Where that's not what he had told his roommates. He told his roommates he killed a bunch of people. And that's how that came in. He opened the door to that. Again, the state didn't introduce a bunch of judgment and sentences saying he had killed other people. They didn't call a witness to his murdering other people. They called witnesses and they said, yeah, he told us he had murdered other people before. McClurg said, I didn't believe him because that's the kind of talk he did. The other witness, Mr. Johnson, said, well, you know, in the context when he said it, as I'm staring at a dead body and there's blood everywhere. Yeah, I kind of thought maybe this was his third kill. So when you consider it in that context, that was completely admissible. And again, when you consider all the evidence in this case, there's a lot of physical evidence. There's eyewitnesses who saw the victim being stabbed. There's blood everywhere. There's medical examiner who said, yeah, by the way, there was no defensive wounds. The victim was wearing a backpack because he was bringing the stolen items back. And that's why there were no wounds on his back. Why there were no wounds on his hands, I don't know. He was running away from the guy who was trying to get away. The backpack got stabbed, but it did protect his back. Turning to the self-defense instruction. First of all, let me say that, again, not only did the defense counsel not object to this, but he affirmatively made changes to this use of deadly force instruction. Everything he suggested was incorporated by the prosecutor and the trial judge. So we're talking about fundamental error here. He never objected. He affirmatively stated he had no objection to this instruction. That's a very different standard. In order to reverse on this basis, they have to show that this completely negated self-defense, his only defense. First of all, it wasn't his only defense. He also argued excusable homicide. But more importantly, there are numerous aspects to a self-defense instruction. And he's complaining about a little bit of confusion in one of the aspects that was not argued by the parties. The jury was specifically instructed.
I just have a clarification question. What is the state's position on whether a defendant can obtain fundamental error review when there's some sort of waiver, below, or some sort of agreement in the purported error? Does the state concede that we still review it for fundamental error, or does the state contend that the defendant does not even get the benefit of fundamental error review?
The case law is not crystal clear on this. There is an invited error doctrine. Where if you can't create an error at trial and then complain about it on appeal, these jury instruction cases walk the line of that invited error instruction. And sometimes the courts say he invited it and it's not reviewable.
Now, I guess the follow-up question then is the state's position that the defendant invited the error, or that merely that the defendant, once the error was introduced, consented to the error? Because those are two at least theoretically distinguishable.
They're distinguishable. I think because the case law is not clear on this, in our opinion, this is invited error when they actually look at these instructions, make changes to them, and then affirmatively say, I have no objection to the justifiable use of deadly force instruction. We would submit that that's invited error. I would say that probably goes a little bit further than the cases have, but logically, I believe that this crosses the line.
Right. I guess that there are like three potential ways to fail to preserve error. One is to invite the error.
Right.
One is to knowingly and intelligently waive the error. And then the other is to forfeit the error. Right. Forfeiture being just a failure to raise it. Right. So
okay.
Invite, knowingly waive, and then simply fail to raise. Do I understand the state to be contending here that the defendant has invited the error, or simply that the defendant, once the error was introduced, has knowingly and intelligently waived the error?
I would argue he definitely waived the error. He affirmatively said, I have no objections to this instruction. He didn't just remain silent. I have no objections. We would submit that by making changes to this instruction and spending time on it like that, and then not bringing up this reportedly fundamentally erroneous portion of the instruction, we would suggest that that's invited error. I don't believe that there are cases going that far yet, but it certainly makes logical sense that that is an invited error. It is in other contexts. Jury instructions, seem to be a little bit more amorphous in that concept. We would submit this is enough to invite the error. But I would agree that the cases have not gone this far, certainly not consistently gone this far. It seems like this is invited error to me. Either way, well, of invited error, you don't review it at all. even if you look at it as waived error, they can argue fundamental error, but the fact that he affirmatively waived it makes it a little bit harder for them to do that. Even under just basic fundamental error analysis, though, you have to look at the context of the instructions and the evidence and arguments of the parties. So here, the evidence of cocaine use came in through the defendant. He testified that they were using cocaine, and then defense counsel argued that that showed how unreliable the witnesses were because everybody was high during this whole event. And so he argued that to attack the credibility of our witnesses. So that's how cocaine came in. The prosecutor never mentioned cocaine in closing argument. Nobody argued that the defendant had a duty to retreat. Nobody did. You will not find that in here. They didn't give that long instruction on duty to retreat. The only way that that's in here is there's two instructions that mention if you're in the course of criminal activity, you have a duty to retreat. But we also gave the instruction that said if you're in a dwelling and it's a house, it's not, this is not a close issue as to whether or not this was a dwelling, then you have no duty to retreat. And there's no mention of criminal activity in there. So there is a clear instruction here. There's also some other instructions about in a place where you have a right to be, then you might have a duty to retreat if you're doing criminal activity, which nobody said he would. The prosecutor, when they mentioned criminal activity, and again, this shows how amorphous this self-defense instruction can be. She said, yeah, he was doing criminal activity. He was plotting to kill the victim. He was committing premeditated murder. That was the criminal activity. Now, the way that actually works is he's the initial aggressor. So did she confuse it a little bit? Yeah, but she made it in the context of where it fits more realistically as initial aggressor. Was he committing criminal activity? Yeah, he certainly was. He went to the door intending to kill the victim. That is in the commission of criminal activity. But she didn't say, and so he had to retreat. She said he was the aggressor, and then that's what the conversation turned to. Nobody said he had a duty to retreat. Defense counsel talked about criminal activity several times in closing argument. He even said during his closing argument, this criminal activity doesn't apply to the drug use. It doesn't apply to the cocaine or the pot. And that is not the state's argument in this case. We are in agreement there. Prosecutor came back and rebuttal. She didn't say, oh, no, we're not in agreement there. She talked about the aggressor. That's what the issue was. And when you look at these cases reversing under fundamental error, it's cases where the evidence was strong and the arguments of the parties were about the duty to retreat, and it shouldn't have been because those defendants really didn't have a duty to retreat under those circumstances. That's where cases are reversed. Let me just point the court to the Farmer decision out of the 4th DCA in 2008, which is cited in the briefs. It was the forcible felony instruction, which was, that is such a problematic portion of this instruction. And for a while, all of the district courts found that to be fundamental, per se, reversible error until the Supreme Court stepped in Martinez and said, no, you can't just reverse all of these cases. That's not how this works. We have to actually focus on the specifics of the case. In Farmer, they gave the forcible felony instruction, but the court said that's not fundamental error here because, first of all, this instruction is complicated. Let's be realistic. The jury doesn't sit and parse these like we do on appeal. They said, considering the difficult jury instruction and all the different aspects to it, the failure of either lawyer to mention the erroneous portion of it, we find that the instruction didn't deprive him of his defense. The prosecutor didn't exploit it. Defense counsel competently argued self-defense without making any mention of this. And 2 experienced lawyers and an experienced trial judge didn't catch this error. We find it hard to believe that the jury would have parsed his instructions in such a way as to ignore the arguments of the parties, ignore the rest of the instruction and just focus on this thing that nobody talked about and reject his defense on that basis. We're not going to engage in that kind of a legal fiction. And the court should not engage in that kind of a legal fiction here. Nobody said he had a duty to retreat. That's not what this turned on. It turned on who was the aggressor. Do we believe him that he just carried a knife to the door because he was using it to cut his marijuana and he kept it with him? Or do we believe the witnesses and the physical physical evidence that showed this guy was plotting all day to get revenge on the victim who stole his stuff and disrespected him. That's what the evidence showed. The physical evidence showed that it was completely corroborated the testimony of the witnesses who were with him that day. And the testimony of those witnesses corroborated that as well. So we have the defendant versus all of the other evidence. And the only issue was who is the aggressor. Given that this was not fundamentally erroneous, it didn't negate his defense. It was just, you're entitled to a fair trial, not a perfect trial. So that being said, if the court has no other questions, we would ask you to affirm his conviction. Thank you.
All right. Thank you, Ms. Davenport and Mr. Crawford.
Crawford, could you address the point about the standard of review for the jury instruction issue?
Certainly.
Invited error, waived, forfeiture, something else, if you could clarify your position on that.
Certainly, Judge Pratt. This court addressed this exact issue in Fuller versus State, which is 257 Southern 3rd 54. In that particular case, this court found invited error. Invited error was particularly found by this court where defense counsel affirmatively requested the instruction. The trial court said, defense counsel, this is an incorrect instruction, and noted that there was a problem with it, and defense counsel still requested it. That is absolutely not what we have here. I would submit to the court that this is a fundamental error situation. It is not a situation like that was found in Fuller case, which is the closest case on point from this court to that particular issue.
If an error is not invited, but it's waived, meaning that there's a knowing and intelligent agreement with the error once introduced, do we still review that for fundamental error?
In this, I would, yes, is the answer to that question. In this particular case, again, I don't significantly see an affirmative waiver here. What we see is defense counsel and the state agreeing on jury instructions, which is done in almost every single case unless there's an objection. In this particular case, defense counsel said he didn't have an objection to the jury instructions. However, you can still review for fundamental error, which I would submit happened in this particular case. To address, did that answer your question, Judge Pratt?
I believe so, yes. And I understand that your position is that there's not been a waiver, but I'm saying
there's not been.
There is a waiver. It's still your position that we would review for fundamental error.
Correct.
Mr. Crawford, could you speak to what Ms. Davenport said about defense counsel seeking revisions of the standard jury instructions and those revisions being made and then an acceptance of the actual jury instructions that were presented to the jury? Did any of those concern the self-defense, duty to retreat?
There is on page 1066 of the trial transcript, I believe, through about 1069. Both sides go back and forth. The defense had some requests to the actual jury instructions themselves. Whether, to my recollection, that did not mention or specifically involve criminal activity and the duty to retreat. I believe there was some suggestions about what to particularly include in the instruction itself. However, again, I would still encourage this court, and based on the case law, to review for fundamental error. Specifically, the law is crystal clear that when someone is in their own home, the jury is supposed to be instructed pursuant to 776.013. The jury was not in this case. Contrary to what the state has argued in this particular case, if the court will look on page 426 of the record, it has the initial comments about, if you're in your own home, then it mentions aggravated battery. Just below that, the court says, or the instruction specifically says, Jake Adam Bellata was justified in using deadly force if he reasonably believed that such force was necessary to prevent imminent death or great bodily harm to himself or imminent commission of aggravated battery against himself. If Jake Adam Bellata was not otherwise engaged in criminal activity and was in a place he had a right to be, then he had no duty to retreat and had the right to stand his ground. That is right there in plain black and white that was read to this jury. Whether or not counsel argued it during closing arguments is a factor for the court to consider, but ultimately the jury is instructed on what the law is. They are told this is the law. These are the instructions you have to follow. In this particular case, the jury was specifically instructed that if Mr. Bellotta was engaged in criminal activity, basically what it meant to them is he had a duty to retreat. This is referenced in two provisions of the instructions themselves. It was not invited error. It's not waived error. It's fundamental error. I'd ask this court to reverse and remand, as the Second District Court of Appeal and the Fourth District Court of Appeal did as well.
All right. Thank you, counsel. Case was well argued on both sides, and we will stand adjourned. Have a nice day.
Thank you, Your Honor. You as well.